Hi, this is Erica, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She has a family and real estate law firm in the Worcester area, and her team are just fantastic. And we are very honored to have you with us today, Nicole. Thank you for joining the show.
Thanks for having me.
You're welcome. Today, we're going to be talking about ADRs, and I guess let's just get a quick definition on that.
ADR is alternative dispute resolution. So it's a way to resolve your case without necessarily the full litigation and trials, essentially.
So as I understand it, there are a few types of ADRs, and I don't know if would you mind walking us through those?
There are three different types that we're going to talk about today: mediation, negotiation, and conciliation. Mediation is essentially where we're going to have a neutral third party that is going to talk to us about the case and try to help us resolve it. Negotiation does not require any third party involved, and a conciliation is where an attorney is appointed to try to help you resolve your case. So three different people are going to be intervening in these types of matters.
How do you decide which one to use? I mean, I'm sure you talked to your attorney about that. Are there any specifics that you can give us that will hint if you should go in one direction or another?
Well, two of them are free, so that's probably always a good point there. Negotiation and conciliation are both free services to the parties. Mediation will most likely cost you. You'll have to pay for the mediator services. Short of that, it is going to be sitting down and talking to your attorney about what will best suit your particular case. And it's also going to depend on whether or not there's another attorney involved. If one party is pro se and another party has an attorney, then you're not going to be able to go to conciliation. So you don't have that option available to you.
That's really interesting. So, I mean, free is always good, but there's also that saying, you get what you pay for, which is, what I like to say to people that don't even want to have their own attorney. Can you bring your own attorney to these different mediations, or do you just work with the mediator by themselves?
You absolutely should have an attorney during any one of these. So whether it's mediation, conciliation, or negotiation, your attorney should be present. Your attorney should be your mouthpiece so that you can get your point across. Again, sometimes the mediator or the conciliator is going to ask you a specific question. Of course they are. Maybe it's something that I'm looking at my client going, I don't really know the answer. You want to tell me? So there's those types of situations. But generally speaking, you want the attorney there to guide you, to kind of cut you off when you're talking too much and we really don't want to go down that road, or just simply to, articulate exactly what needs to happen and exactly what you are looking for.
Yeah, I mean, I find that the rules are kind of the same with how you should act in a mediation and how you should act in court. I mean, if you've hired an attorney to be your mouthpiece and they can be calm, cool, and collected, and they know what's going on and they know the right strategies, you should be quiet. I mean, is that the kind of advice you typically give?
Absolutely. I mean, I think it's one of those things that in both conciliation and mediation, there is a confidentiality, which means anything that you say there will not be used up in court. But guess what? If you've already tipped your hand in mediation and they already know my bottom line number was 20,000 because I opened my mouth and my attorney didn't kick me, then we're going to go in front of the judge and we're going to say, Your Honor, we have made a reasonable offer of settlement. They refused to take it, and we know it's something that they're willing to do. You kind of got your point across, didn't you? Without saying exactly what happened. So it's really one of those things that you really want to know what you can say in mediation, what you shouldn't say. Again, let your attorney be your mouthpiece.
I mean, it's no secret that you are my attorney, and the couple of times that we've done mediation and I have found it so much better than trying to just talk with your ex, because that is like an emotional bomb goes off. And at some point, you're not going to be negotiating anything. It has been so much nicer to have you talk for me. And in some of the cases, they do these things over Zoom. You don't even have to be in the same Zoom room with your ex in some cases. I find that to be way more relaxing. It's such a stressful situation anyway when you're going to court or when you're trying to iron things out through mediation.
Absolutely. And I think that's the big thing is, when you're in that mediation session or the conciliation session and you're there in front of your ex, they're going to make those trigger points. They know what they are. They're waiting for it because they want to go, see, I told you we could get her. And that's exactly what they're looking for. So it's one of those things that, again, silence is better. Obviously, if not even being in the same room, much better. And absolutely, that's what you're going to have that situation that sometimes you're going to be in that room together, but it's probably going to be very limited in time. And again, if you just listen to the two attorneys that are speaking and the mediator, the conciliator, and then all of a sudden you're separated, great. The hard part is over. You can breathe now. So you really only have probably 10 minutes where you have to be in the same room or the same Zoom room together, and thereafter you're separated. And then you can have an honest conversation with the mediator outside of the scope of your spouse. Or you can have the conversation with your attorney and you can kind of brainstorm as to what your high number is, your low number is, whatever that looks like.
I mean, and what's good too is that sometimes things happen in mediation that may need further exploration between you and your attorney, or maybe maybe you need more of an explanation of what's going on. Because let's face it, when you are not an attorney yourself, you don't always know what the words even mean or the strategies or what's going to happen next, and that can be scary and stressful.
Absolutely.
So, can you tell me how long do each of these types of resolutions take?
Really depends on the amount of topics that we have to talk about and the amount of time that each party is willing to kind of sit through it, negotiate, have an honest discussion. Generally speaking, negotiations are probably the fastest in length, but also the longest in duration. And what I mean by that is it's usually the attorneys going back and forth. So you'll have a quick burst of negotiations, and then we're waiting for the other side to come back with a counter offer. And so we're in a hiatus and we're waiting. And unless we're doing it in the courthouse, that could take, 4 or 5 months when you're going back and forth. If you're in the courthouse, obviously it's going to be a little narrow and you're probably only going to be there about an hour going back and forth. So it kind of depends on the context of where you are and what you're actually negotiating, and what the method is of negotiation. Again, if I'm writing you a letter and I'm sending you a formal offer, then I have to wait for snail mail, or I have to wait for you to talk to your attorney and there's a process there. If we're doing mediation, you're going to have it as a session. Generally, I've never seen mediations. Well, I can't say never, but the reality is most mediations are going to take 2 to 3 times. So again, how quickly can you get back in front of that mediator really depends on your schedules. But looking at it, you're probably going to have 2 to 3 sessions of mediation. Generally speaking, the mediation sessions last about 2 hours each. Conciliation usually is a one and done. So you're going to have one session, usually 2 to 3 hours in length. Sometimes they will have a second session. You'll never get a third session in conciliation. And the second session usually is about an hour to an hour and a half. So the duration, again, would depend on how quickly you can get there, but that's really the time frame.
What I liked about our last mediation was that we actually met with the mediator on our own, and then there was a separate meeting for the other parties where they met ahead of time of the mediation in preparation for the mediation. she then made sure that all of the documents that were necessary were actually there so that we could have an intelligent conversation when we did have the mediation, which I found that to be a lot less stressful than past mediations, because you really got to talk about the issues ahead of time and on your own time.
Absolutely. And I think you weren't as rushed. Generally speaking, mediator is going to block out a certain period of time. It's 2 hours or whatever the case may be. And you're going, oh my God, but there's so many things I need to talk about, and I need to address this, and I need to address, and then you start stressing. And when you kind of go, okay, we've already laid out the 10 or 15 issues. They've laid out their 10 or 15 issues. We've exchanged what we needed to so that we could have that productive conversation. So again, even if that mediation session jointly is narrowed down to 2 hours, we've already narrowed down kind of what we know we're going down, what path we need to be on. And more importantly, we've already exchanged the information. So it definitely is helpful.
Nicole, would you talk about the partial decisions? Like, you might have a whole list of issues, but sometimes you can go back to the judge and say, well, hey, judge, at least we cleared up half of the issues, which is less work for them in the court.
It is. And hopefully you have a reasonable attorney on the other side that won't go, it's all or nothing. That's really frustrating to me, because it's like, well, wait a minute, we just negotiated all of these things that we have an agreement on. Well, yeah, but we don't agree on this last issue, so everything's off the table. So assuming you have a normal attorney that's going to say, hey, we've made super progress here, let's reward the parties by doing a partial stipulation. And maybe the partial stipulation is just a temporary order versus a judgment, but it's something. It's something to put in writing, and something to also show the judge that the parties are making good faith effort to resolve their issues. So it's huge in everyone's mind. The parties are happy because I can finally breathe on that one topic. I don't have to worry about it anymore. Again, whether it's a temporary or final judgment, they now go, I've got closure, which is huge, right? We as attorneys go, great, now we don't have to worry about litigating those issues. We don't have to worry about additional discovery on those issues. Moving on, let's move forward. So it gives us that reprieve. And it also shows the judge that we are trying to make every resolution. The other thing is, we've narrowed down that issue. We then can present the one or two issues to the judge and say, well, if we saw this facts presented, judge, what would that look like? And if we saw this, the opposite end, which is what the other party's looking for, what would that look like? So we can get the judge's perspective without saying exactly where we're at, and saying we have option A and option B. Judge, what's your opinion? And she may choose option C, but she may also lean toward A or B. And then we at least understand where she's coming from, what she's looking for, and how she's going to make that decision, which is huge for us to then go back to mediation or conciliation and say, hey, now that we've got the judge's insight, let's move this forward in some other fashion. And we did that exact same issue this morning. I had a conciliation last week. We went in front of the judge, and the first words out of the judge's mouth is, well, where are we at? And opposing counsel said, well, I have an offer that we've been negotiating back and forth. Great, go back to conciliation and let's see where we can come up with before we get a trial date. That's huge.
Now, you said that 2 of these were free, but mediation costs money. So can you tell me, like, what is the range? I know that you can find it for different prices, but I know that cheaper is not always better.
Absolutely. And I think, in terms of that, it really depends on what type of mediation services you need. And obviously, again, what we're talking about. The reality is there are places that do sliding scales. For the most part, you're going to be paying the rates of the mediators, which really range from probably $200 to $450 an hour in the state of Massachusetts. Depends on where you are in the state itself, which county you're in, stuff of that nature, what the experience is. But I would say that that's the general range. And again, we're going to look at probably splitting that cost. So if the mediator is going to ask for a $4,000 retainer, you're only coming up with $2,000. And again, the same principles apply, that unless they're showing it as a flat fee, it's all going to be based on their hourly rate, and they'll refund any money that's unused.
Can you give us an example or explain, like, from start to finish, what happens in a mediation?
In a mediation, the mediator is most likely going to go through the guidelines, if you will, what they're going to expect from you. So again, they're going to be neutral. Everything remains confidential. You're not going to call them in. They're going to accept, they're basically going to set the stage of what that mediation session is going to look like, and that you're entering into it freely and voluntarily. So those are all the things that the mediator is going to discuss in advance. They may just have you sign the form, but generally speaking, they're going to go over that form with you that you signed so that you understand all of those terms. Then once we actually get into the mediation, again, we could have something that we did with yours, which was a pre-screening, if you will, of the mediation. But assuming we don't have that, then they're going to have the four parties, the parties there, the two attorneys and the two parties and the mediator. We're all going to be in the same room, whether it be in Zoom or in person, and we're all going to discuss our issues. They usually start with the moving party first, the plaintiff first. Then they'll go to the defendant, ask the defendant their position, and then from there, we're going to do a breakout session. The mediator is going to determine at that point, which party do I want to talk to first? And they're going to put you in separate rooms. Again, whether it's a Zoom room or a physical room, you're going to go into a separate room. The mediator is going to talk to one side first and their respective attorney, and they're going to discuss issues. And there's a separate level of confidentiality there. So again, what I say with that mediator isn't going to necessarily be given to the other party, unless I wanted to. So maybe we bring up a little bit more issues. He's an abusive control freak and he beat me every single day. Well, I didn't bring that up in the general session because I didn't want to hear him say, no, that's not true. That's not true at all. And of course, your response is going to be, yeah, but I have a million restraining orders and I have a million arrest records. Again, not going to be productive in a general session, but in a private session, I can bring those situations up if my goal is, hey, I have issues with parenting time because of his abusive nature. So those where I bring that up. Then once we have our say, then the mediator is then going to go to the other side and have the exact same communication with them, private and separate. And the mediator is going to go back and forth and or bring us back to a joint session to see where we've resolved issues, how close we are, or just have a general communication saying this isn't working.
I mean, well, that's really great information. It's good to know. And a lot of people don't know until they have to do it. So are there any parting comments that you'd like to make? Any suggestions or advice if you do have to go through mediation? Because a lot of divorce agreements actually have that written in, whereas if you have any issues that come up, you have to go to mediation before you go to court. And that's really just meant to save money. Like, so you're not just running to court every 5 minutes. You are forced to sit down and try to come up with a resolution before you go to that next level.
Absolutely. And I think it's definitely beneficial. And I think any ADR is beneficial. I mean, spending time and trying to negotiate outside of the court, if nothing else, saves you a lot of time and aggravation with the court system. You don't have to take off all the days off from work to go there multiple times. You don't have to spend the cost for a trial. So there's definitely benefits overall. And you're the judge. You ultimately get to decide what you're willing to accept. And if you're not willing to accept it, then you do have that judge that's going to make that decision. But they're also going to allow you to be that judge of your case and your kind of overall analysis of how you want to do it. Now, I will say this, again, we talked a little bit about what negotiations look like, but conciliation has a different feel for it. So again, conciliation start to end is going to look a little bit different. Conciliation is going to be where, again, we're going to probably go through what the conciliator expects of you beforehand. That, again, it's confidential and you're entering into it freely and voluntarily. After that, The conciliator is going to start out exactly like a mediator and go through the process of listening to the plaintiff side, listening to the defendant side. They will then, at that point, separate you. However, in a conciliation, sometimes the conciliator is going to talk to the parties and not their respective attorneys. Sometimes they're going to talk to one side versus the other side. So it might be a little bit back and forth. You're going to start out in that joint session, but again, we're going to go to private sessions. What that private session really is going to look like is going to depend on the conciliator. So sometimes it's going to be 4 of us back together immediately after we have a short private session. Sometimes it's going to be I'm only going to talk to the parties. Sometimes it's I'm only going to talk to the attorneys to knock some sense into the attorneys to go back to talk to their clients. So that has a little bit of a different feel versus the mediation. You're always going to be with your attorney no matter what. So conciliation, sometimes people feel like, oh my God, what is my attorney doing behind my back? Don't think that way. There's no conspiracy. Again, sometimes we need to have candid conversations. Sometimes it's really, well, what's your sticking point here? You know, we can fight over the law all we want, but what's going to settle this case with your client? And sometimes we're going to do that with just one attorney and go back to just the other attorney. So that dynamic's going to look a little different. Generally speaking, the conciliator will come back at least at the end and have all 4 parties there to discuss the final resolution, whether it be we're ending the session and we haven't come up with an agreement, we're ending the session and we have a partial agreement, or we're ending the session and we're going to come back, or we're just done and we need to walk away. So conciliation has a little bit of a different feel.
And if you have any further questions about what happens when your attorney isn't with you, go back and watch our video about where did my attorney go? What's my attorney doing when they're not with me? It's all good things. Well, I want to thank you so much. That's a complicated topic, and it's very helpful if you can get it to work the right way. If you're working with the right people, with the right attitude, try to be open-minded. And, so thank you so much for that. We really appreciate your advice.
Hopefully we learned something and you're not as scared about the situation moving forward. But again, I would absolutely second that. Is we're not there to just run up your bill. We're there to actually help you, even though we're not in the same room with you sometimes.
That's right. Well, thanks again, everyone, for watching. Have a great weekend. Until next time.